At the Supreme Court, justices heard oral arguments yesterday in the first major abortion case under the Trump administration, and they clashed over the Louisiana law that requires doctors to have admitting privileges in hospitals to perform the procedure. Now, the law is expected to close nearly every clinic in the state if it's upheld by the Supreme Court. So CBS News reporter Kate Smith has been all over the story for a long time, and she has the latest from Washington. We spoke to you yesterday, Kate, when you were just outside, and you could hear the protesters and sort of demonstrating just for and against this law. So we know that this is a very heated topic, but you were also inside the courtroom yesterday. Give us a sense of, what the arguments were on both sides.
What I really honed in on is these justices are really concerned about the practicality of this law. At the center of this case is a deeply complex, kind of confusing, to be honest, legal idea. It's whether or not a rule that was found unconstitutional in 2016 is today constitutional, and is it constitutional in other states? So what I found is the justices were honing in on the practicality. On the ground, how does this law play out? They were less interested in kind of the legal arguments surrounding these, and more interested how people on the ground who are seeking this procedure would be impacted if this law were to go into effect. And I particularly found that to be of concern among the female justices. They were asking, how long does the average person have to drive to get an abortion? When there are complications, when do those happen? So my take from this was that these justices are very interested in trying to hone in on exactly how people would be impacted if this were allowed to go into effect.
So as I understand it, Justice Alito and Justice Ginsburg, they were the most vocal during arguments. Is there any chance that they may actually find some middle ground here?
Yeah. So Alito and Ginsburg were very vocal, but on two very separate issues. So Alito was very concerned about the standing issue at the center of this case. Now, this is a kind of a complex legal idea, but it's the idea that an abortion clinic inherently can't represent patients when they're challenging abortion restrictions. It's the idea of third-party standing. And now, what the state argues is that because they are a business that offers abortion, they're naturally and inherently in conflict with their patient's best interest. And so, of course, Center for Reproductive Rights, the firm challenging this law, says we are not in conflict of those interests. We have a close relationship with our patients. We understand what they need. And additionally, it seems to them unreasonable to ask a woman who is pregnant, seeking an abortion, and of course, important to remember, many women who seek abortions are often low income. They often already have a child. Asking one of those people to go 5.5 years through a court case that could end up at the Supreme Center for Reproductive Rights says that's unreasonable. So that's what Alito was really honing in on. He wanted to know why, women and people in Louisiana can't represent themselves when the state levies abortion restrictions. So that was Alito's argument. Now, Ginsburg, like we were mentioning, very, very concerned about the impact of this law. It was very clear that she knows exactly how abortion regulations play out on the ground. She was very interested about where complications happen when there is a problem with an abortion. So at the center of this law is Louisiana's admitting privilege regulation from 2014. It's the idea that a doctor who performs abortion needs to have admitting privileges at a hospital no less than 30 miles away. The idea being if something wrong happens at the clinic, they're able to transfer the patient to that nearby hospital. But what Ginsburg was honing in on is that when complications do happen, they're often not at the clinic. They're often at the person's home. And then further, she noted, in Louisiana, there are only 3 abortion clinics. So often that person's home can be very far away from the clinic. And so I was particularly interested that she really knew a lot about the delivery of abortion in this state, had a lot of specific knowledge about that, and was able to hone in on questions that are really asking, just kind of the nuts and bolts of how this law would play out.
So Chief Justice Roberts actually voted to strike down a very similar law in 2016. A lot of what we have talked about leading up to this is that, there was a similar law in 2016, but the court makeup is different now. It's leaning towards a more conservative bent. But for for Justice Roberts, he voted against it in 2016. What would have to change for him to change his mind at this time around?
So the state's argument here is that the law that the Supreme Court struck down in 2016, the Texas law that we've been talking about, that is inherently different from this law for two reasons. The idea is that the regulatory structure in Louisiana is different from Texas, and the impact would be different. So Roberts, in his questioning yesterday, was clearly trying to figure out, are these two laws different? And I found one thing interesting here. Kavanaugh and Roberts had a very similar line of questioning. The two of these justices are trying to figure out, are admitting privileges, the law at the center of this case, are those regulations inherently unconstitutional, or is it because of the impact they have on the state? Here's why that's so important. If they're inherently unconstitutional, then the idea would be that no state should be allowed to implement these. However, if they are unconstitutional just because of the impact they would have on the state, that would mean that every single state who passes a law like this would need to have their own hearing, their own legal process to figure out if their specific admitting privilege law is unconstitutional.
And so before we let you go, what's going to be going on next with this case?
Everyone's just waiting. The justices will deliberate. They'll take everything that they heard yesterday, all the questions, the presentations, and all those briefs, and they're going to deliberate. And we won't have an answer until later this spring. But something to keep in mind here is that this is a critically important abortion access case. It will change the landscape of abortion delivery no matter what the justices say. So we'll be following this and really trying to understand exactly what would happen in Louisiana depending on no matter how the justices decide.
All right, Kate Smith, thank you so much.